Good morning, everyone. It is 8 o'clock on the dot, and we have a lot of material and content to get through. So we're going to get started. Um, Today, my name is Stephanie Fedorka. I'm an attorney here at Schoeneck King in our labor and employment practice group. I also work in our school law practice group, providing day-to-day counseling and advice to clients in school districts, charter schools, private schools, all types of employers. Today, we're going to be talking about the FMLA and other leave law basics. The goals for today are to really talk about, really focus on the FMLA, but I want to give you practical pointers and tips with respect to other protected leaves of absence or how to manage leaves of absence, because I feel like a lot of the potential risk lies in how an employer works through documents and shows their work in administering some sort of leave of absence. So we're going to talk a little bit about what laws apply. We'll talk a little bit about the interplay, how some laws overlap, interact, or run together. Keep that in mind. But again, heavily focused on the FMLA today as a refresher. And we'll talk about some common mistakes or pitfalls and how to avoid them. I have a nice list. I'm a big checklist person, so I have a nice list of things that I see that are common, either mistakes or pitfalls or accidents or things that some employers just aren't aware of when they're administering, whether it's the FMLA leave or some other leave of absence. So we'll talk a little bit about that and things to keep in mind. So getting started with our federal laws, this slide provides an outline of the various federal leave laws, right? Today we're going to be talking about the Family and Medical Leave Act, FMLA, but don't forget that there's other leave laws that apply at the federal level, the Uniform Services Employment and Reemployment Rights Act, USERRA, that relates to military leave, as well as the ADA, the Americans with Disabilities Act, the Pregnant Workers Fairness Act, or the PWFA, and Title VII of the Civil Rights Act, or Title VII. Those are not leave laws in and of themselves, fundamentally, but each one of them creates an obligation to provide reasonable accommodations for qualified individuals, whether with disabilities, on the basis of pregnancy, childbirth, or related medical conditions, or for sincerely held religious beliefs and practices and observances. And so it's pretty well established that unpaid leaves of absence could be an accommodation for any of those. So it's something to keep in mind, because even if there may not be, a common question that I get, for example, is when someone has exhausted their FMLA, is there anything else that we have to, do we still have to provide them with additional leave if they still cannot return to work because of their own medical condition? And the answer is perhaps, right? You might have to under the ADA as a reasonable accommodation, as well as New York State laws. So there's a whole lot of laws under the New York State law that could apply to schools, whether private or public. So again, we're not going to get into all of the details here. It's really just to illustrate and to be an FYI, right? When you take home these slides and look at them and keep them in your drawer as a reference, right? If there is a particular reason that an employee has provided to you that they need a leave of absence and it fits into one of these categories, that should be a red flag to take a pause and to make sure that you're looking at whatever applicable policy you have, or looking at the law, or contacting legal for some help to navigate, to make sure that you don't create some exposure for your organization just by virtue of inadvertently, violating one of these various leave laws. New York City as well, in case there's any New York folks down in New York City. New York City has its own laws, so don't forget about the New York City human rights law that also requires accommodations for disabilities, pregnancy, childbirth, and related medical conditions, as well as victims of domestic violence, stalking, and sex offenses, and religious beliefs, practices, and observances. That's similar and quite similar to the state law. New York City also has the temporary schedule change law and safe time and sick time law as well. So just for our New York City friends, another reference slide for leaves that may apply and to be mindful of, right? So diving into the FMLA, and I'll say, we're going to go through some of the highlights and the keys and provide a refresher of the things that you need to be aware of to, well administer an FMLA leave of absence, or what happens if you think FMLA may apply. But we could spend hours and hours and hours talking about the FMLA, and we only have 45 minutes together. So to the extent that you have any follow-up questions, do not hesitate to send us an email, and we'll be sure to follow up with you offline. So as a quick refresher, right, the FMLA provides unpaid leave to eligible employees for up to 12 weeks for most qualifying reasons in any 12-month period if they work for a covered employer. So a covered employer is either going to be a private employer with 50 or more employees or public employers, regardless of the number of employees. In terms of who is eligible for this leave, so employees that work for one of those covered employers will be eligible for FMLA after they've been employed for at least 12 months. They have to have worked at least 1,250 hours during the previous 12-month period, right? That's going backwards from the day of the leave, the FMLA leave is supposed to start. And they have to work at a work site where at least 50 or more employees are employed by their employer within a 75-mile radius of that work site. Only those employees are going to be eligible to take FMLA leave. Qualifying reasons. So I like to break this up into two separate categories, right? We have our basic FMLA, which is going to be bonding leave, right? Leave taken to care or bond with a new child following the birth or placement of a child for adoption or foster care. Care for a family member with a serious health condition, right? That's going to be an employee's spouse, son or daughter, or parent with a serious health condition, or if the employee is unable to work themselves because of a serious health condition. The second category are qualifying reasons for military FMLA leave. And so some of those have slightly different rules and a 12-month period. So important to keep those distinct, I think, to avoid confusion. I like using this nice chart of what a serious health condition is, right? It's going to have to fall within the definition under the FMLA law and corresponding regulations. So it's going to require some sort of either inpatient care or continuing treatment, and then follow one of these, right? If it's continuing treatment, 3 or more days of incapacity, or 2 or more treatments, or continuing regimen or treatment. It can be taken for pregnancy or prenatal care. Chronic serious health conditions, permanent long-term conditions, or multiple treatments. Military leave, there are highly specific examples, but it also breaks down into two kind of subcategories of military leave. So there's qualifying exigency leave. So that's when a family member has been notified of an impending deployment to a foreign country. It's up to 12 weeks of unpaid leave in that 12-month period for various purposes related to that pending deployment, right? Making different childcare arrangements, attending official military ceremonies, et cetera, et cetera. And then military caregiver leave. So that's care or time off that is available to care for an injured or seriously ill service member or veteran. Note that could be an up to combined 26 work weeks of unpaid leave in a 12-month period. So there's a little bit more provided under that particular type of FMLA category. While someone is on FMLA, they are entitled to continuation of benefits as if they were actively working. So an employer can require an employee to remit payment, right? The employer doesn't have to front the payment. One of the common issues or questions that I get, right, is if an employee is on a company or employer-provided sponsored plan, and they are paying their employee share of premiums and the employer is paying their employer share of premiums, right? When the employee goes out on unpaid leave, what's going to happen to continue those benefits, right? Someone's going to have to pay. And the employee is responsible for continuing to remit payment. Sometimes if an employee is using PTO, right, oftentimes that is the case. They choose to use PTO or the employer can require the use of PTO, and we'll get into a couple of those nuances on the next slide. But if they're using PTO, typically what most employers do is they continue to make those deductions from their PTO just like if they were actively working. So it's really not an issue. Where it becomes an issue is if someone has exhausted all of their PTO or the employer's policy does not require them to use PTO and perhaps they're saving it for another reason. So they're taking unpaid leave. What happens then, right? And an employer can require the employee to make those payments and my recommendations with respect to that are to make sure you clearly communicate at the outset of the leave what is expected, if anyone is going to have to repay anything, or when it's going to be due, right? The payments are in this amount and they're due on the 1st and the 15th of the month, or whenever they may be due. They have to be sent to HR or payroll or whomever is collecting the money, right? So another, opposite of remittance of payment, I've also seen employers who will front the payment. If you're going to do that, I caution, right, where situations have occurred where an employer will front the payment because the employee is going to be out for 8 weeks, right? They extend the leave and then they've exhausted FMLA, it continues on and on and on, and suddenly the employer realizes that they've been fronting the payment for something, either 12 total weeks or something well beyond, right? How are we going to, recoup it, et cetera, et cetera. I think it's a best practice and really critical to communicate with the employee if that's going to be the case. If you are going to advance the payment for some finite period, right, whether it's 4 weeks or 6 weeks where they're out on their FMLA leave, or the full 12 weeks, you should clearly communicate to them that you will be recovering that via payroll deduction when they come back to work, right? Or they will be responsible for remitting payment in some other way. I think clearly communicating that at the outset helps to protect yourself. And sometimes the employee will make some decisions, right, regarding maybe remitting payment along the way, or maybe they will just it won't come as a surprise to them, right, when they come back to work and now they have to pay back 12 weeks of employee share premiums. Use of PTO. So the FMLA does allow employers to require the use of PTO while an employee is on unpaid FMLA leave. There's an exception in the FMLA regulations where if FMLA is running concurrently when an employee is receiving some other paid leave benefit, like workers' comp or short-term disability, even going as far as PFL, again, to the extent that that applies to your workplace, if you're a public employer and you've opted in, or if you are a private employer, or school and have to provide the PFL, then the employer cannot require the use of PTO during FMLA, but you can permit the use of PTO during FMLA. In any regard, whatever you choose to do, you should communicate that clearly in writing. We'll talk about important things with respect to your policies in a little bit. We won't get into all of the details, but one thing that I will say over and over is making sure that you have a robust and comprehensive FMLA policy, right? We'll talk about your notice obligations, and you have to provide certain information to employees about their rights under the FMLA. But I think that there is a lot of value in tailoring and customizing your FMLA policy, again, within the parameters of the law, but to include important information, right, that is relevant and that employees should know about, particularly, right, regarding the use of PTO. What's your policy on that, among other things? Okay, the 12-month period. So I had mentioned that FMLA, right, basic FMLA is going to be available for up to 12 weeks in a 12-month period. So the time period for basic FMLA leave, right, you have 4 options as an employer. You can use a calendar year. You can use any fixed 12-month period. And some examples that the U.S. Department of Labor that provides are an anniversary day, a fiscal year, or other 12-month period required by state law. So if there is another state FMLA law that may apply, and it goes by a particular period, then maybe you follow that to keep them consistent and running concurrently and avoid confusion. It's a 12-month period measured forward from the first date the employee takes FMLA leave, or a rolling period, a rolling 12-month period measured backward from the date that an employee takes FMLA leave. Generally, that last one is the one that is most beneficial to the employer, but it's ultimately your decision, right? As long as you select it and you have to use the same period for all employees. So you cannot pick and choose, right? Some employees are going to be using an anniversary date, 12-month period. Others are using a rolling period. Others are using measured forward period. Excuse me. So pick one and stick with it. If you're going to change a period, so say you have selected a particular FMLA period and you're going to change it, you have to provide 60-day notice. And there's some other obligations regarding communication of that to employees. So be mindful of that if for some reason you find yourself in a position where you're going to change your FMLA policy and move from one 12-month period measurement to a different one. And notably, I think this is what I see more common, right, or more often in policies or lacking policies that I review, is that employers fail to select one of the four methods. And if that happens, if you don't clearly communicate to an employee what your 12-month period is, then the employer has to use the 12-month period that is most beneficial to the employee when those FMLA requests come up. With respect to the 12-month period for military caregiver leave, it's different. That is a 12-month period. It begins on the first day of the leave and ends 12 months later. Totally not dependent on whatever you select for the other basic FMLA 12-month period. Okay, some of the terms of use of leave. FMLA can be taken intermittently or continuously, right? It does not all have to be taken at the same time. Oftentimes, an employee, particularly if it's bonding leave, right, they may take intermittent leave. They might take a week here or a couple days per week, or they might take a couple of weeks right after a baby is born or the new child is placed, and then they will take some more time later. We'll talk about, on my second bullet point there, right? The bonding leave must be used within 12 months of birth, but we'll follow up kind of how that might come into play in a little bit. Interestingly, I've seen more requests for a reduced or a schedule or modified work schedule, right? Not only is that, you might think, oh, well, that's a reasonable accommodation. If someone is unable to work because of their own condition, right, and maybe they need to work a reduced or modified schedule, it certainly could be an accommodation. However, FMLA also recognizes that you could take FMLA leave to work a reduced schedule or modified work schedule for one of those qualifying reasons. So that's something, to also be aware of when you're, for lack of a better way to put it, issue spotting, or when an employee comes to you with a request for a particular schedule or need of time off, right? This has come up. I've seen this come up with respect to requesting not to work overtime, and it could apply for that. So, keep that on your radar in case those things do come up or you see those things and types of requests come from employees. Intermittent leave for bonding with the new child is only available if the employer agrees. I think what I see more commonly is that the employer does allow that, right? If an employee is going to want to take intermittent leave for bonding with that new child, right, in that first year, they will allow that to occur. But in some cases, it might be disruptive or it might not be workable, right? And so if you choose not to allow intermittent leave, right, again, it's something that I think you should decide what your policy is on that and communicate with employees in your written policy regarding whether or not intermittent leave for bonding with a new child will be available. For those employers who have opted into PFL, or PFL does apply to them because you are a private sector employer or school, note that that rule is not the same for PFL. PFL is available intermittently for bonding with a new child. So in that particular situation, you will have to allow the employee to use their FMLA and PFL intermittently so that they can run concurrently. But again, only applicable if PFL, New York State Paid Family Leave, applies to you. Okay, other common FMLA employer obligations, just as a refresher, right? Remember, you have to have that FMLA poster. They recently updated it. Now it's like a purple color. You can download it from the U.S. Department of Labor's website. You have to display that in plain view where employees and applicants can readily see it. Some employers will put that in their handbook. It contains a lot of information. Regardless, right, other than the display and the poster requirement, you also have an obligation to provide notice of the FMLA rights upon hire to employees. right? You can either provide that poster, or I generally recommend providing the poster along with a tailored FMLA policy, again, that is more comprehensive. You have to put it either in your employee handbook or other written materials about leave and benefits that you have. If you don't have an employee handbook, right, and that might be okay, then you've got to still provide the notice upon hire to each employee by some way. Again, my recommendation is always to have a comprehensive written policy that includes helpful and customized and tailored information about expectations, what you've selected for that 12-month period, use of PTO, all of that good stuff in a written policy, how to request the leave, all of those things, right? What's going to be expected when you come back, if you're going to require a fitness for duty certification, et cetera. Put that in a nice written policy and give that to employees upon hire. Okay, eligibility notices. So I see this, come up quite frequently as well, where the FMLA requires employers to provide an eligibility notice within 5 days of an initial request for leave, or when an employer has enough knowledge to know that the employee might be requesting FMLA leave, or the leave that they are seeking or maybe seeking could be FMLA qualifying. This is what one of the things I see a lot is that this is not just a requirement of employees who are eligible. Even if an employee is not eligible for FMLA leave because they have not met one of those eligibility criteria, right? Maybe they've only been with you for 6 months. They have not worked for you for 12 months. So they do not qualify for FMLA. You still have to provide them with that eligibility notice. If you use the eligibility notice form that the Department of Labor has put together, there is a space to check, that the employee is not eligible. And you can check the reason why they're not eligible. One of those, right, whether it's they didn't work a year, they haven't worked 1,250 hours in the past preceding 12 months, or if they don't work at a work site with at least 50 employees within a 75-mile radius. So again, make sure you are in a good habit of giving those eligibility notices to all employees, again, within 5 days of that initial request. Rights and responsibilities notice. Every time you provide that eligibility notice, you should also be providing this rights and responsibilities notice. And so this WH-381 is the U.S. Department of Labor's consolidated form. It contains both that eligibility and the rights and responsibilities. So you can utilize that form. I recommend that clients and employers use that form because it has everything that you need on there, right, that you need to communicate. That said, you can have your own form as long as you include all of the required information that the FMLA and corresponding regulations require you to put into that eligibility and rights and responsibilities document. So I think, needless to say, I think it's easier and a little bit more efficient to use that WH-381 form. Designation notice. Don't forget that once you have sufficient information to determine that leave qualifies as FMLA, then you have to provide a written designation notice within 5 business days, absent extenuating circumstances. That's going to include, it has to include information about the use or substitution of PTO, fitness for duty certifications when they're coming back to work, the amount of leave that's going to be counted against their entitlement, again, based on what you have in terms of information regarding their needs for FMLA leave. You can use this WH-382 form. Again, it's a nice form that the U.S. Department of Labor has put into place or has put together that you can use that has a space for all of that information. Okay. There are some school-specific rules just to be mindful of, right? There are specific rules for instructional employees that are using intermittent or reduced schedule FMLA leave, as well as when they're using FMLA leave near the end of an academic term. And then there's also special rules for all employees of public school boards or public or private elementary and secondary schools when they're returning to work after FMLA leave. Note that these don't apply to other educational institutions, including preschools. I say that just in case we have any folks on joining the webinar that might fit into one of those categories. So keep those in mind in case you have an instructional employee that's requesting intermittent leave or reduced schedule leave, as well as requesting leave that's near the end of an academic term. That should, raise some red flags to look at those rules and see if there's any particular applicability to your situation or what options might be available to you. So returning to work, I've mentioned a couple times that fitness for duty certification. You can require that. If you're going to do that, you have to notify the employee that will be a requirement at the outset of the leave. So it cannot just be a spontaneous last minute, we need a return to work note from your physician or your healthcare provider. Reinstatement. The employee has to be reinstated. They're entitled to reinstatement to the same position that they held when their leave started, or to an equivalent position with equivalent benefits, pay, and other terms and conditions of employment. There are certain exceptions. There's a key employee exception, right, for the 10% if they're an employee that are in the top 10% of compensation within an organization. But other than that, you have an obligation to return that person to their position when their FMLA has concluded. To set yourself up for success in the long run, right, making sure that if you're putting a substitute or some sort of replacement while this person is out on leave, that it's temporary in nature. You're not hiring a permanent replacement so that you're in a conundrum of having to terminate that person to reinstate this other person, or you're left with no position to really reinstate this person too. So if you're going to fill in that position while that employee is out on FMLA leave, just keep in mind to keep it temporary, right, and be prepared to reinstate that person when they come back. Remember that the FMLA has protections against retaliation. I'll also mention that there are things called FMLA interference claims to be aware of, right? And that can come in the form of, and I think I have this on a future slide, but that can come in the form of, probing the employee while they're out on leave, when they're coming back, or encouraging an employee to come back early, or discouraging an employee from taking FMLA leave in the first place. So you have to be careful. This is something really to communicate with managers or whoever is, helping to administer the leave, right? Making sure that people are not interfering with an employee's rights under the FMLA. Sometimes good intentions, bad results, right? We are intending to check in with the person every, 2 weeks, 3 weeks, or whatever to see how they're doing. I discourage that in most situations, unless there's a really compelling or good reason to be checking in that frequently, because that could feel coercive. That could make the employee feel like you're seeing if they're going to come back early, or making statements about, oh, well, do you think you can come back sooner? Or we could really use your help, right? Again, anything that could be construed as an employee's interfering with an employee's right to take leave or to exercise their rights under the FMLA can be problematic. On the retaliation point, right, I have another slide that briefly talks about some things to keep in mind, right? If we're taking action against an employee while they're out on leave, so disciplining an employee when they're out on FMLA leave, I always have a ton of red flags go up in my brain, and we need to pause and really figure out what's going on before we make that decision, right? I'm not saying in all, there might not be exceptions where perhaps there's a long history of well-documented performance issues or misconduct or the like, and suddenly something comes to a head while they're out on leave, right? Just happened to be the timing. But short of that, more times than not, almost always, right? If you terminate someone on FMLA leave, that will tee you up for a retaliation claim that will be nearly impossible to overcome, right? So be mindful of that. Same thing when they come back from leave. Terminating an employee on the day that they return from FMLA leave is going to cause a bunch of red flags and going to tee you up for a retaliation claim. So be careful about that, right? If there's an issue that comes up, I highly, highly recommend you work with legal counsel, work with your favorite BSK, labor and employment attorney, or whoever, right? To talk through what's going on so that we can give you the best advice on the risk, because terminating someone as soon as they come back from leave or shortly thereafter is going to look retaliatory, it's going to feel retaliatory, and it's going to be very difficult to overcome some sort of retaliation claim unless we have a lot of really good documentation beforehand, or some objective good documentation that will be able to prove that the real reason we're terminating this person or disciplining this person is this legitimate, unrelated issue, right? Okay. So I like thinking about things in steps. I think it's helpful. I think it keeps me organized. And so I wanted to share with you kind of a step-by-step guide with respect to leave administration, right? This should be a refresher. An employee tells you that they need to be out of work for, insert anything really, right? But maybe let's focus on the employee needs to be out of work because they are having a medical issue, right? So they are unable to work. And this is applicable FMLA or other protected leaves, really any leave of absence, any time away from work. If you work through this step-by-step process, you will do a good job at making sure you have your T's crossed, your I's dotted, you've gathered the information you need, and you're going to set yourself up for success. So step one is going to be identify what leave laws or policies apply, right? There may be more than one. Oftentimes, right, we see if an employee is out because they suffered some sort of workplace injury, right? They're out on workers' comp, and that should run concurrently with FMLA, right? Same thing with short-term disability. If someone's out on short-term disability and receiving short-term disability benefits, that needs to be run concurrently with FMLA to the extent that, right, they're eligible for FMLA, of course. So identify what leave laws apply and what policies apply, right? If you offer some more generous policy too, or if you have some internal policy that speaks to the particular absence, right, or purpose for the absence, then make sure you're reviewing that and you're complying with your policy as well. Step two is going to be acknowledging the employee's request and notice, and you request additional information if you think that's necessary. So for the FMLA, I listed all the forms, those medical certification forms or certification forms that you can use when an employee says that they need to take leave related to their own serious health condition or a family member serious health condition, et cetera, et cetera. You do not have to use those forms. You do not have to request supporting documentation. I always encourage you and strongly recommend that you do, because then you can get relevant information about why this person needs to be out on leave, right? Do they even qualify for FMLA or any other leave benefit or policy that you might have? Do they, how long do they need to be out? Are there any other limitations, right? Is it possible that perhaps they don't need leave and maybe we could accommodate this through some alternative reasonable accommodation? So gathering all that information ahead of time you'll get your bearings on what this person may need and so what might apply. So these are the forms that you can use that the Department of Labor has put out. I encourage using these forms as well because there are limitations under the FMLA of what you can and cannot ask for in terms of supporting documentation or information. With respect to, and I'll talk about this, I suppose, in another slide or two with respect to documentation, some things that come up, but we can push back a little bit on the documentation. If the form comes back, and it happens all the time, a healthcare provider will complete the form and send it back, and we still have questions. You should promptly and specifically identify what follow-up information you need or clarification you need before you designate it. Once you designate the leave, right, once you've accepted the medical that you have or the certification that you have, you can't go back and ask for more medical or more follow-up information unless you meet one of the exceptions, right? If there is a significant change in what the employee needs or there's concerns about, potential fraud or something like that. So it's important to really make sure that you are on top of the medical at the outset before you approve it. And again, this is somewhat of an expeditious process. You really shouldn't be sitting on these forms and waiting around to get to them. You should be reviewing them promptly and following up with the employee in writing with respect to any particular or specific information that you need clarification on, so that you can designate the FMLA, or, right, if it doesn't qualify, make that determination. I've mentioned the interplay of multiple leaves, right? Very common and typical for more than one leave to be running at the same time. And making sure, again, that you're running if someone's out on workers' comp, that should be running with FMLA, short-term disability, PFL, again, to the extent that that is applicable to your workplace, or any other statutory entitlement or protection. Be sure to include that in your written policies and notices to employees. That should be in your FMLA policy. That should be in your other corresponding policies, right? So it's very clear that these are going to run concurrently. They are not stacked. So that an employee could take, 12 weeks of FMLA and then 12 weeks of PFL and then, so on and so forth. So with respect to following up on my discussion on requesting information, right? When you're requesting information from employees regarding a leave request, you should know or understand or seek information about what is the purpose of the leave, right? Why does this person need to be out? How long does the employee need to be out of work? Is it intermittent or continuous, right? Those types of things. Again, with respect to FMLA, right, you can use those forms. You'll note that there's no bonding form because you can't ask for certification with respect to the bonding leave, but you can certainly ask for, and you should ask for, information about what they are looking for in terms of that bonding leave, right? What is their schedule? What are they looking for? When do they need to be out? When will they be back? Is it intermittent? Is it continuous, etc.? And I had mentioned, right, note that there's limitations on recertification while someone's out. Once you have accepted and designated that leave under that particular, right, certification or whatever process, you can't recertify with the exception of a couple of times, right? And so you got to, I emphasize this because it's important to look at everything from the outset. And again, the thing that I see happen most often is we get a request or a certification back from the employer and their healthcare provider, and it's not clear. We have questions. Instead of saying to the employee something very vague and just saying, this isn't clear, we need more information, be very specific. The FMLA requires you to be very specific about what is insufficient and what information you specifically need in order to approve the FMLA or make a determination on the designation of the FMLA. Note that there's also similar types of limitations on documentation and information that you can request from employees under the ADA, the Pregnant Workers Fairness Act, and the New York City human rights law, right? So be careful in terms of what you are asking for. Overly broad requests for medical documentation or information that are not relevant could put you in some hot water. So make sure that they also aren't really helpful, right? And so make sure that you are being specific in what you are asking for from the healthcare provider or the employee, and how that will help you, move the needle in terms of making a decision on what they need in terms of leave or accommodations or otherwise, right? Okay, so jumping back into our step-by-step guide, right? Step 3 is going to be reviewing and evaluating additional information that you receive, right? Once you look at that, right, make sure you figure out if you need any other follow-up, that you do that, you ask for specific information. Another note to mention, right, the FMLA has timelines for the period that you have to give an employee to return the documentation. So originally, they get 15 days to return that certification to you. If they don't return it in the 15 days, it doesn't mean that you can automatically deny the FMLA leave, but it's not that leave that they might be taking after that period, right? After that first 15 days, if they are out at that time, is not protected until they return that documentation. If you need follow-up documentation or clarification, then you give them another 7 days to return that to you. Even if FMLA isn't applicable, right, in any sort of leave situation where you are looking for, or even accommodation situation, when you're looking for additional information, medical information, or other details that you need to, as part of your interactive process or evaluation regarding the leave of absence that they're seeking, put a timestamp on when they should return that documentation to you. Again, not talking about the FMLA, right? I generally say 10 to 14 days is pretty reasonable to have an employee return whatever requested information you are looking for. Be gracious if they need an additional couple of days because either healthcare provider's out of town or couldn't get to it or whatever. Be gracious in that, but in extending extensions, right? But you should put a timestamp on that because oftentimes I will see situations where employers requested specific information and they sent it to the employee and weeks have passed and weeks have passed and weeks have passed and the employee has not returned it, right? And I think it's a little stronger and easier when we, as the employer, have put a due date on that information. And we can follow up with the employee after those 2 weeks have passed, or in the FMLA context, right, the 15 days have passed, touch base. We haven't heard from you. We haven't received this information. It's very important for us to receive this information in order for us to continue with this process regarding how we can accommodate you or regarding your FMLA, leave of absence request, right? That way, if the employee never responds, right, you've given them reasonable opportunities to respond. You've given them a timestamp, and that way you can kind of move your process along efficiently, right, in terms of, okay, we've met our obligations under the law, and the employee has abandoned that process. Step 4 is going to be communicating the decision and other information with the employee, right? Remember, if it's the FMLA, you're giving them that designation notice in writing. Even if it's not the FMLA, I encourage you to confirm whatever decision it is regarding the leave of absence to be in writing, right? So that way you can say, we've approved your leave of absence that runs from January 1st to March 10th or something, right? Whatever it is. That way it's clearly in writing, you've documented it, there is a particular leave of absence approved, good documentation, right? In that documentation, you should also include other information about use of PTO during the leave, right? Is it going to be required? If it's FMLA and unpaid, is it permissible? Expectations while they're out on leave, including any transition plans, right? If this is a requesting leave way ahead of time, making sure that the employee is communicating a transition plan and putting anything that you expect of them before they go out on leave. Any communication, right, reiterating that they should not be working while they're on FMLA leave or some other protected leave of absence, right? You should include information about the return to duty notes or fitness for duty certification, right? Insurance continuation, including any arrangements that you've agreed upon regarding their remittance of payment or if they're going to repay, and if the district or the school is going to advance the payments for insurance, the premiums, etc. All of that good information should be in that approval letter, if you will. If you're not approving it for one reason or another, right? If it's that the employee has abandoned this process and you've made efforts, right? Again, your documentation is going to be very important because it's going to memorialize in real time the efforts you have taken to try to collect the information you need from the employee, the lack of responses, the lack of information that you have, and therefore, right, if it's a denial or if it's, we can't, grant this for not necessarily FMLA, but if it's a leave of absence request unrelated to the FMLA, right, we cannot grant this because it's not reasonable, whatever it might be, that should be well documented and communicated. I encourage you to reach out to counsel on those communications because you can almost guarantee that if this issue with this employee or this leave of absence or accommodation, whatever it might be, results in some sort of claim, right, that document is going to be an exhibit, and you want that to be as helpful as possible to your position, right? So work with legal counsel to make sure that your communication is really strong and good in the event that some sort of claim comes up. Step 5, follow up with the employee before the leave comes to an end, right? Check in. I generally say maybe about 2 weeks before the employee comes back to work. Check in with them. Say we're looking forward to having you back. And it also allows you the opportunity to ask if they need any other restrictions or limitations to please let you know so that you can plan accordingly. And step 6 is returning to work, right? Follow up on any limitations or restrictions if the employee is out for their own condition, right? Do they need any accommodations? Go through that process. I'll also mention, right, that there could be situations where the employee needs more leave time, right? They have exhausted the FMLA. You might still have an obligation. You still, if it's because they are unable to work, you have an obligation to engage in that interactive process with them to see if an extension of unpaid leave, even though they've exhausted the FMLA, would be reasonable, right? And I will say more oftentimes than not, an employee who needs a little more time because they're still recovering or still unable to return to work because of their own serious health condition, if it's unpaid leave that they're looking for, it's going to be reasonable most of the time, absent undue hardship. But again, that undue hardship standard is very high. So keep that in mind, right? Do not just terminate that employee on the expiration date of their FMLA leave, and welcome them back and see if there's anything else that they might need upon their return to work. So that brings us right to the end. I know that was probably a lot of information. I hope it was practical and useful, but if you have any questions or if there's any way that we can help, please don't hesitate to reach out. I hope you have a great rest of your Thursday.